Good evening, everyone. My name is Ashley Johnson. Thank you for joining us for tonight's presentation, Protect Yourself, Umbrella of Powers of Attorney and Healthcare Directives. It's a bit of a mouthful, but I'm sure it will be a great program. While we can't see or hear you, we encourage you to use either the chat or the Q&A feature on the bottom of your screen, and our presenters will be able to see and answer your questions there. So be sure to put them in as they come up. We are recording this, so you'll be able to view it on our YouTube for a while. So I'll send that out to registrants after the program. Now I'd like to introduce our guests, Karen Nadoff and Alan Press. They're attorneys with Shire Law Group in Lincolnshire, a premier estate planning and elder law firm serving the Chicagoland area for 25 years. A friend to the library, they offer a lot of programs with us every quarter or so. So Karen received her law degree from Temple University, where she was the recipient of the Outstanding Legal and Research Writing Award and was named Who's Who among American law students. Alan received his law degree from Loyola University of Chicago and was awarded the American Jurisprudence Award in Federal Taxation. Wow, that's I don't know what that means. In addition to being a lawyer, Alan is a certified public accountant. Welcome to our friends from Shire Law Group. Hello.
Thank you.
You're welcome. I'm going to go behind the scenes, but I'll be right here if you need anything. So you can share your screen.
All right, great. Let me go. So make sure everybody can see that okay. And I guess we can get started.
Looks good.
Right, so welcome everybody. Thank you so much for that introduction. And welcome to this evening's presentation, Protect Yourself, Umbrella of Powers of Attorney and Healthcare Directives. As introduced, I'm Karen Nadoff from the Shire Law Group.
And I'm Alan Press, and Karen and I are both partners, and we're very happy to be with you this evening to discuss this topic about powers of attorney and healthcare directives.
So we're going to go ahead and get started. And as mentioned, if you have any questions, please answer them. Put them into the chat box and we'll get to them as soon as we can. If we don't answer something directly, it's probably because we're about to get to it during the presentation. If you have questions after the presentation, we'll stay around a little bit afterwards for any questions that you want to ask through the chat. But if you want to contact us directly, please feel free to do so. We like getting questions from the community. You can call us at 847-955-9000 or send us an email at Karen, that's Karen at shirelawgroup.com, and Alan, ALAN at shirelawgroup.com. And with that, we're going to get started. So we're going to discuss what you need to know to protect yourself. We'll be touching on the interplay between powers of attorney and wills and trusts. We're also going to be speaking about the importance of powers of attorney and healthcare directives. And we're going to review the ideal plan to protect you and your family now, as well as in the future. So before we get started, it's very important to have an overview of estate planning to see how those powers of attorney and healthcare directives fit in. So we're going to get started with that.
Great. So let's take a look at what is estate planning, just so we have a little bit of basic background here. So it's typically a process. You normally would use an attorney to help you prepare for your future by planning for who you want your wealth, your assets, and your property and other things to be gifted to after you pass away. Those people that you're gifting to are commonly known as your beneficiaries. You also want to plan for how you want your wealth, your assets, your property, and more to be gifted after you pass away. It may also involve directing your healthcare and guiding your finances during lifetime. So it doesn't only focus on what happens if you pass away, but it can also focus on what happens during your lifetime. Maybe if you become incapacitated and you're unable to make your own decisions. And that is a big part of what powers of attorney can be used as a solution to accomplish making sure that things are set up properly. You may also use estate planning to plan for either minimizing or avoiding taxes. And you could also use it to minimize or avoid a probate process. And probate, we'll talk a little bit about that, but that's basically going to be a court proceeding when somebody, typically when somebody passes away, in managing their estate and making sure that things are getting to where they need to be. So those are some of the goals that people have when they talk about doing estate planning. So first, let's kind of start off with one of the most common terms is a will, or also known as a last will and testament. A couple of things to keep in mind. A will is only going to be effective at death. And we're going to contrast that later on to the powers of attorney, because the powers of attorney are actually only effective during lifetime. So these documents handle two different time periods. A will is going to allow you to designate a guardian or guardians for your minor children, if that's relevant to your situation. And a will is going to instruct a probate court as to who you want to receive what. So we've all seen, things on TV when people die and somebody may have a will and there might be a reading of the will. They don't really have those in Illinois typically, but it's really more a creature of television production and drama. But basically, I could have a will that says when I die, I want everything to go to my spouse. And if my spouse has predeceased me, then I want all of my assets to be divided in equal shares to my children. And then my spouse might have the same will that's just reciprocal. So she might be leaving everything to me. And if I predeceased her, then she's leaving her estate in equal shares to our children. So that's a typical example of what a will is. Let's now contrast that to a trust. Like a will, a trust is also a legal document that you create. The person who creates the will, the trust, is called the grantor, and you create it during your lifetime to streamline the administration of your assets during life and also planning for what's going to happen after death. So a trust is almost like a super document. The will is only effective at death. The powers of attorney are only effective during life. A trust is actually effective immediately upon execution, and it stays effective potentially after death as well. A trust is popular because it's going to help people to avoid the probate process that we talked a little bit about. So it could be a big time saver and saver of money. A trust is also going to provide more privacy than a will, because a will, when you pass away, is going to need to be filed with the county in which you resided at the time of your death. So the will becomes public record after death. And if there's a probate proceeding, potentially all of your financial business, what assets you have, who they're going to, whether you owed anybody any money, could also become part of the public record through a probate proceeding. So a trust is very popular because it maintains privacy and nothing is recorded in the public record. A trust can also provide maximum control even after you're deceased. So let's say let's go back to the example of my children. Let's say that they're not good with money. And if I passed away, I don't necessarily want them inheriting my money without some sort of conditions or structure as to when and how they're going to receive it. So a trust allows you to create a management vehicle after death to control the distribution as to how the money will be distributed. It's also going to enable the trustee that you designate in the document to take control after you're no longer able to handle your own affairs, exactly what you want to have happen. So you can become very specific about the way things are going to work, even after you're no longer around. And also, because it's effective during lifetime, it's very effective in planning for disability as well as death. A will can't do that because a will is only effective at death. So if I create a trust, I can also put provisions in there that are going to help me help my successor trustee manage my assets for my benefit during my lifetime if I were incapacitated. So let's take a look at a couple of features of trusts. Trusts are going to give you more control as to how assets are distributed. Trusts do need to be funded. So it's one thing to create a trust document. We've been doing that for over 25 years, so we're really good at that. The hard part of this type of work is putting it all together, getting the trust funded, making sure that beneficiary designations are set up properly, making sure that your assets are lining up with what you set up in your trust documents so that after you're no longer around, things are going to work exactly the way that you expect them to. The trust avoids probate. We've already talked about that. Trusts are private. We've already touched on that as well. And trusts can help you plan for disability because they're effective during a lifetime. So what happens though if somebody dies without a will or a trust? Well, if they don't have any of those documents in place, they die what's called intestate. And Illinois has a statute that provides for who will receive your assets if you die without any other direction set up. So if you have no will or trust, so it determines who receives a deceased person's assets in absence of a valid will or trust. It's only going to apply to probate property. And this is a very important point, because if I have a life insurance policy and I name my son as the beneficiary when I die, that doesn't need to go to probate whether I have a will or not, because I have a contract with the life insurance company that says when I die, I want you to pay the life insurance proceeds to my son. So typically all my son has to do is get a death certificate for me and fill out a claim form, and then he would be entitled to claim those funds. So that happens irrespective of a will or trust and does not need probate. So probate only applies to property that is in the deceased person's name alone. So they don't have any joint ownership. There's no beneficiary designation. So if I have a bank account that only has my name on it and I pass away, that could potentially go to probate. If it's a joint account with my spouse and I die, she automatically, my spouse, becomes the owner of that property by virtue of being a joint owner. So you do want to keep that in mind when you're doing your planning. Also, if the probate assets in the aggregate are less than $100,000, you can avoid probate anyway and do what's called a small estate affidavit in order to transfer those assets. But let's go back and take a look at the Illinois intestacy laws. Let's assume that I pass away and I have no will or trust. What happens to my probate property? Well, per the statute, if I die with a spouse and descendants are really just a fancy word for children and grandchildren, basically the estate will be divided equally between my spouse and my children. If I pass away with a spouse and I have no children, then my spouse gets everything. If I pass away with children but no spouse, then my children get everything. And you might be saying, well, what's wrong with that? It actually sounds pretty good. So I may not need a will, but let me pose this to you. So we did have a client, so this is a true story, a young family, husband and wife with 2 small children. Husband owns the family home that they reside in. It's only in his name. I think the reason might have been because his spouse did not have good credit, so she wasn't on title. She wasn't on the mortgage. So the home was solely in the husband's name. Husband passes away. He has no will, no trust, no nothing, and he owns this house. So what happens? Well, we actually needed to do 3 different probates, one for the husband. And then we had to do separate guardianship probates for each of the minor children, because minor children can't inherit money. Looks like I froze. Can everybody hear me okay?
Yes, we can hear you.
Yeah, you're back.
All right, thank you. Sorry about that. So what happened was that the house, basically the wife had to repurchase the home back from her own minor children. So I have to think that that probably wasn't the intent of the husband, that he probably would have wanted the home to go directly to his spouse. And then his spouse, of course, would have taken care of their children in the marital residence. But under that situation, mom had to buy back 50% of the property from the 2 guardianship estates that were established for each of her children. So not a result that really helped that family. So having a simple will, if the husband had one, would have really saved a lot of issues there for that family. If a deceased person is only survived by parents or siblings, then the parents and siblings are going to equally inherit a share. However, if one parent is deceased, the surviving parent winds up getting a double share. So if I have 3 brothers and a mom, but my dad is deceased, that's going to be divided up 5 different shares, but my mother will get a double share and my 3 brothers will each get a single share. If a deceased person is not survived by parents, brothers, sisters, or descendants of brothers and sisters, the estate is going to be split equally between maternal and paternal sides of the family, basically who's ever left. And if a deceased person is not survived by anyone, then the estate is left to the state of Illinois. Keep in mind, though, that although these laws are in place to divide the assets and distribute them to the family members as beneficiaries, of course, if the person who died owed any taxes or debts or expenses, those things would have to be taken care of first before the money could be divided up.
All right, let's talk a little bit about planning for disability. So what happens if you become incapacitated? So a lot of times, like Alan said at the top of the presentation, people think about estate planning, these documents, all about, what happens when I pass away. But there's a very important piece of planning that involves incapacity because we just don't know what's going to happen. So planning in advance for it is essential. So there's different ways that you can plan for disability. One is through a revocable living trust. So what Alan was just discussing, in your trust, you can make some parameters around incapacity and planning for that. You can also plan through a power of attorney for property, a healthcare power of attorney, a HIPAA authorization, a declaration for mental health treatment, a living will, and a DNR. And you can see that there are some asterisks next to some of these documents, that healthcare power of attorney, the HIPAA, the declaration for mental health treatment, the living will, and the DNR. So all of those documents together is what makes up what is known as your advance directives. And we're going to talk about each one of these documents one at a time. So importantly, once you turn 18 and you're considered a legal adult, that's when these documents need to be put in place. So upon 18, when you turn 18, if you have a child who turns 18, at that point, your access to their medical records, to decision-making, to their financial affairs becomes limited without these documents in place. So that's just something to keep in mind too. There's a lot of misunderstanding around this. A lot of people think, oh, as long as my child's still at home, or if they are at school and in college and I'm paying for that education, I can still make financial decisions for them, medical decisions, but that is not so. So once your child turns 18, they also need to have these documents put into place. Very important, you must create advance directives and powers of attorney while you are still able to make decisions for yourself. So you can't create a power of attorney or healthcare directive after you have an injury or an illness that is going to prevent you from making your own decisions. So in other words, you must be mentally competent to create your advanced directives. Planning ahead is very important. If you're in a situation where you don't have these documents in place, something happens, you're unable to sign them, then you're in a precarious position. So these documents are fairly simple to put in place, and planning ahead, as we're about to see, becomes very important. So we're going to start out with that power of attorney for property. So the power of attorney for property is a financial document. So think of property in the broad sense, not just real estate, but anything financial in terms of bank accounts or investment accounts. These are also known as financial powers of attorney or durable powers of attorney. At Shire, we call them power of attorney for property. They're different names for the same document. So the power of attorney for property is a written document in which you give someone the power to make decisions on your behalf about your property and your finances if you become unable to make these decisions for yourself. And Alan's going to talk a little bit more about this particular power of attorney.
Thanks, Karen. So the power of attorney, again, you may recall that powers of attorney are only going to be effective during lifetime. So you're appointing an agent to make decisions for you. And per the statutory form that's available in Illinois, these are all of the different powers that you're conferring upon your agent that the agent can make. So, real estate transactions, financial transactions, stocks and bonds, personal property, access to a safe deposit box, insurance and annuity, retirement plan, Social Security, employment and military service benefits, tax matters, claims and litigation, commodity and option transactions, business operations, borrowing transactions, estate transactions, and just generally all other property powers and transactions. So these are pursuant to the Illinois statute and form. And when you execute a power of attorney, you can cross off any of these that you feel are not relevant, or if you have an objection to any of them. Now, typically in our office, we recommend that you don't cross anything off, because even if something doesn't apply at the moment, there's a potential that it could apply in the future. And really the idea here is to make the form as useful as possible. We prefer to promote having it be broad as opposed to narrowing its scope, because you never know what's going to happen in life. And certainly if you cross off a power that might be needed, that's going to render the form useless for that purpose. So you really want to stay away from that. In addition, in our office, we actually create pages and pages of additional powers, because the statutory form allows in paragraph 3 of the form to add additional powers. And in Illinois, like many other states, if certain powers are not specifically provided for in the power of attorney, there's a possibility that the agent acting under the form is not going to be able to do that. So we want to make sure that that doesn't happen to our clients. So, just to give you a sampling of some of the things that we put in there, we add powers regarding digital assets, because the standard form does not provide for that. And of course, that's extremely important. You want to make sure that if you're acting on somebody's behalf in a power of attorney, that you have access to things online and that are in digital format. Gifting is very, very important. It could be important for estate tax planning, income tax planning, and it's also very important for long-term care or Medicaid planning. So without specific and gifting powers, again, your agent may be precluded from doing things for you. We do some elder law in our office, and it's always a shame when somebody comes in and they want to do some planning for Medicaid, but they're really not able to do that because the power of attorney that they have doesn't specifically set forth any gifting powers, and the person that they're trying to help is suffering from a cognitive impairment typically, and they can't execute a new power of attorney. So that becomes very important. Funding a trust, again, doing some long-term care planning, like entering into caregiver agreements and things like that, dealing with retirement plans, more specific access to safety deposit box, dealing with credit card companies, and many more things that we add to the power of attorney for property. So our theory at our office is you can't make this broad enough. So we really try to throw everything in there except the kitchen sink to make sure that anybody acting under the power of attorney is not going to be precluded from doing what they need to do in order to help the person that is the principal under the document. So the power of attorney for property can handle many different things. You saw some of the examples. It's also very important in handling tax issues. In fact, we put in our office specific authority to fill out the IRS power of attorney form that the IRS is going to be looking for in order to assist somebody with a tax issue. Of course, banking and even dealing with things having to do with the Department of Motor Vehicles. So there's plenty of things that a power of attorney can assist with. They're all financial related. I will back up for a second and just say that it's called the power of attorney for property, but keep in mind that that's property in the broadest sense. So it's not just real estate property. It's any type of property, asset, bank accounts, personal belongings, anything of that nature.
So we're going to switch the focus from financial to medical. So there's several medical related documents that we're going to take one at a time. And the first one we're going to talk about is the healthcare power of attorney. This is also known as a medical power of attorney or a healthcare proxy. And again, at Shire, we use that healthcare power of attorney, different names, same document. It's a written document in which you give someone the power to make decisions about your healthcare on your behalf if you become unable to make or communicate these decisions yourself. The people that you're appointing are known as your agents. And in Illinois, you can only list one agent at a time. So you would list them in the order you would want. Importantly, with these documents, you're not giving up your own rights. They only come into play, this healthcare power of attorney, when you cannot make your own medical decisions. So as long as you can make your own decisions, you're going to. But if you cannot make your own medical decisions for some reason, this healthcare power of attorney is very important to have in place because you are naming those people that you want to appoint as your agents to step in and make decisions for you. So in the statutory form, and again, we always use the Illinois statutory forms in our office. We just add additional powers to make them broader. These are some things that you'll find that your agent can do for you on your behalf, should you not be able to make your own medical decisions. They can decide to accept, withdraw, or decline treatment for any type of physical or mental condition that you might have, including life and death decisions. They can agree to admit you or discharge you from a hospital, home, or other institution, including a mental health facility. They can have complete access to your medical and mental health records and share them with others as needed, so they can act in your best interest, as well as carry out plans you've already made, or if you haven't made plans, they can make decisions about things like organ donation. If you've indicated that on your driver's license, then they would carry those plans out for you. So the importance of these powers of attorney for healthcare really come into play, again, if you cannot make your own medical decisions. So at that point, when you're appointing an agent to step in on your behalf, at Shire, we want to make sure that those agents have a very broad ability to act in your best interest. So we add additional powers to those statutory forms. And some of those powers are listed here. The ability to hire a care manager, so somebody who would look over your care and be able to manage it, as well as hiring a companion, if that would be something that was necessary or they felt that that would be helpful. To hire a patient advocate. So during COVID, patient advocates become very important. When you can't go into the hospital with a loved one, you can hire a patient advocate. That's somebody who's on the inside of the hospital who can get information out. But even outside of COVID, this could be very important. What if a loved one was in a hospital, you couldn't get them right away to the hospital to see what's going on, or you lived far away, or you just wanted somebody who could get information out when you needed it? You could hire a patient advocate as an agent for that individual, if that's listed as a power that's available. And also we add maintaining you in your residence. So if it's reasonable, you would want to stay in your residence. And we have many, many more powers that we list. Again, in Illinois, if you don't list specific powers, your agents might not be able to act upon them. So we just want to make sure that when we do these powers of attorney for our clients, that we are listing many, many additional powers. So if the agents need them, they're there for them to utilize. So just to give you an example of how important this is, and this will go back to a young adult, one of my friends had a daughter who was going to a large university. It was the first time that she was going away from home. And my friend was concerned about getting her acclimated to that university and had advised her to maybe join some kind of group, intramurals, club sports. So she joined the soccer intramurals and was having a great week, meeting people. Everything was going great. At the end of that week, she's on the soccer field and she collides with one of her teammates and she's injured very badly. She's away from home again for the first time. She ends up in University Health Services. She is in a lot of pain. She does not understand what is being said to her, told to her. And fortunately, my friend had a power of attorney for healthcare in place that she was able to send to University Health Services and make decisions on behalf of her child. So fortunately, she had these all situated and all set up. When we do our powers of attorney and our healthcare directives, we always have electronic copies, and we highly advise that as well when you put these in place, and you keep these electronic copies in a safe place, in an easily accessible place. So if you need to, you can send them out right away. If you have a loved one in a hospital, you can easily get to your power of attorney that you have for them, send this off to the hospital and be able to make decisions on their behalf. The electronic copies are just as good as the original or a copy of the original. And in an emergency or a crisis situation, you are going to use the electronic copy. You want to be able to make decisions right away if you need to do that on behalf of somebody. The next document is an information receiving document. So your power of attorney for healthcare is a decision-making document. Your HIPAA is about information. HIPAA stands for the Health Insurance Portability and Accountability Act. We are sure that you have all signed HIPAA forms at one time or another with your doctor's office. It's a written document that allows healthcare providers to release and share medical information with people you designate to receive this information on your behalf. Unlike your powers of attorney, where you can only list one agent at a time in the order that you would like them to act, for your HIPAA authorization, you can name as many people as you would like to be able to receive your protected health information, and there's no order to that. So anybody that you list in paragraph 1 on your HIPAA authorization for authorized recipients have the same right and the same standing to call up that hospital or emergency room you might be in and get information. So these become extremely important, especially if you're in an emergency room that you've never been in before. And the time that you enter that emergency room, you're unable to communicate who should be notified. You're unable to fill out their forms. So your HIPAA authorization that you've done in advance names those people, and they know that they have your authorization. They can send the HIPAA to the emergency room and be able to get information about what is going on. So these HIPAA authorizations are extremely important. So this is the statutory form, this HIPAA form. It says, with your HIPAA authorization, you authorize the release of your protected medical information, including medical reports and records concerning your medical history, condition, diagnosis, testing, prognosis, treatment, billing information, and identity of healthcare providers, whether past, present, or future, as well as any other information that is in any way related to your healthcare to your authorized recipients. So you can see this is all about, again, information, not a decision-making document, but just about getting information to anyone who would need to know, should you be in a situation where you're in an emergency room, you're in a hospital, and you want that information about what's going on with you shared with your loved ones that you've named in your authorization. So I can tell you personally, I have had to use these. I had to use it for my son. He was very ill. He is fine now, but he had a very bad virus and he ended up in an emergency room he had never been in before. And he had his phone with him. He had called me and told me when he was on his way to the hospital that a friend was actually taking him and that he didn't realize that he had very little battery left on his phone, but his friend had a fully charged phone and was going to keep me updated and text message me as soon as they got to the hospital. So of course, your heart is racing when something like this is going on. You're in the middle of this situation where you really don't know what's happening or what's going to happen. And his friend texted me and told me that they were at the hospital, but they would not give the friend any information because he didn't have proper documentation and authorization to receive it. So I quickly called up to the nurse's station and they told me that they couldn't even tell me if my son was admitted because they didn't have records to authorize that. So electronic copies, I had them situated. I know where they are. I can get to them easily. I immediately sent out this HIPAA authorization to get information. I also sent the power of attorney for healthcare just in case I had to make medical decisions on his behalf. I sent them off, called up the nurse's station again. They apologized. They said, we're sorry. We needed to have this documentation before we could release any information. And they proceeded to tell me exactly what was going on. And I was able to keep updated. And it turned out that everything was fine. But without this HIPAA authorization on file, I would not have been able to find out what was happening with him in those moments. So cannot overemphasize the importance of all of these documents. So the HIPAA authorization, even if you have some HIPAAs that you filled out at your doctor's office, it's very important to have a general HIPAA authorization in place. We also want to talk about the living will declaration. So this is often confused with a will, because it's called a living will, or a living trust, because it has the word living in there. And that's what Alan was talking about earlier in the evening. The living will is a healthcare directive. It's a legal document which states your wishes regarding life support in the event you are in a persistent vegetative state or irreversible coma, and you cannot communicate your wishes. So we can show you what the living will says. It says, if at any time I should have an incurable or irreversible injury, disease, or illness judged to be a terminal condition by my attending physician who has personally examined me and has determined that my death is imminent except for death delaying procedures, I direct that such procedures which would only prolong the dying process be withheld or withdrawn, and that I be permitted to die naturally with only the administration of medication, sustenance, or the performance of any medical procedure deemed necessary by my attending physician to provide me with comfort care. So when you go into the hospital and they say, do you have a living will declaration? This is what they're talking about. It's an optional document. If you agree with it, you could put that in place and that would be part of your healthcare directives. In Illinois, there's also a declaration for mental health treatment, another optional document. And if this applies to you, you could put this in place as well. The declaration for mental health treatment allows you to choose whether you want to receive electroconvulsive treatment, ECT, or psychotropic medicine when you have a mental illness and you're unable to make decisions for yourself. And you can write on the declaration your wishes and choose someone to make mental health decisions for you. So if this is something that applies to you, Illinois has this available as a healthcare directive as well for you to put into place. We also want to talk about DNR because there's a lot of confusion that surrounds DNR. DNRs do not resuscitate. This is actually a doctor's order. It has to be signed by your physician, and it's a medical document or order which tells doctors not to restart your heart or breathing. So normally doctors are going to give CPR when you stop breathing or your heart stops. You do not want to put a DNR in place if you would want your heart or your breathing restored. So some of the reasons that somebody might want to put a DNR in place is because maybe they're at the end stage of a terminal illness and they don't want to be resuscitated, or they've had numerous heart attacks. And if they have one more, they just do not want their heart to be restarted. So before you sign a DNR, it is very important to understand what the DNR says. And again, it has to be signed by your physician. This is a doctor's order.
And actually, Karen will point out too that on the DNR form, you can mark off that you do want to be resuscitated, but in our opinion, there's really no reason to sign that document because there's a potential that the first responder may not read it carefully or may misunderstand it. So if you do want to be resuscitated, generally it's our advice that you don't even have a DNR anywhere. And of course, if you do not want to be resuscitated, then you can fill out the form. But we don't like that box on there that says, I do want to be resuscitated, because we think it just provides confusion for first responders. Also, people ask us, okay, so we prepare these documents, they seem to be based in Illinois, and that is correct. So many of the documents that we're talking about are Illinois statutory forms. We've already mentioned that we kind of beef them up with additional powers and additional things that we put in there, but we're still using the statutory framework. And the reason is because we want to make sure that the forms are easily recognized by whomever they're being presented to. So if you're going to a financial institution with a power of attorney for property, we want to make sure that that financial institution is not going to give the user or the agent under the power of attorney a hard time about the document. They'll easily recognize it. The same thing with a healthcare power of attorney. We want to make sure that the medical provider is going to easily recognize it and not say something like, well, geez, I never saw this before. Maybe we have to send it down to the legal department before we can honor it. So we want to avoid that problem. That being said, these are Illinois-based forms. However, as long as they are executed properly, being signed and witnessed and notarized if necessary, as long as they're executed properly in the state of Illinois, they're going to be valid in all 50 states. So if you're traveling, or let's say you decide to move, is your Illinois power of attorney for property going to be valid, in the state of Florida or the state of Texas or Tennessee? And the answer would be yes. Now, of course, if you're doing a permanent move somewhere, we do recommend that perhaps you consider changing your documents if the state that you're moving to offers their own set of forms. They're typically not that difficult to complete and usually not that expensive. This is different than wills and trusts, which tend to be more universal in their use. So we don't really use like an Illinois-based trust or a Illinois-based will. Those wills are more nationally accepted and similar. Of course, in those documents, we may make a reference to the fact that if they needed to be interpreted, they should be interpreted under Illinois law, but certainly they could also be used in any of the states. So the documents are useful. This is also relevant to the issue of young adults. We do a lot of work with 18-year-olds. In fact, we get many 18-year-olds in our office on the day of their birthday signing their documents. I could probably think of better ways to spend my 18th birthday, but let's say they're going off to college and they live in Illinois, but they're maybe going to school in Pennsylvania or California or Washington, D.C. Will these forms that they've created here in Illinois be valid in those different states? And the answer is yes, they will be. As long as they're validly executed here in Illinois. So what happens if you don't have these documents that we're talking about, the powers of attorney, especially in the area of medical decisions? Who gets to make medical decisions for you if you don't have a statutory healthcare power of attorney? Well, there is what's called a surrogacy law in Illinois, and it lays out a pecking order of who would be able to make decisions for you if you don't have these documents in place. And basically, if there's a court-appointed guardian, that would always be the first choice. Otherwise, it would be a spouse. If not a spouse, then adult children. If not adult children, parents and so on and so forth. You can read the list right here. So again, you might say, well, geez, that's a pretty good list. I mean, what do I need to do these documents for if these people are going to be able to make the decisions anyway? Well, the problem is that they are not going to be able to make the decisions to the same extent that they would be able to if there was a written power of attorney. So certain decisions are not allowed under this statute unless there is a formal power of attorney drafted. So the other thing too is with the power of attorney, of course, you can pick who you want to make the decisions. Who you're going to choose may not line up necessarily with this list. So that's the other advantage. And also the ability to put things in the power of attorney, particularly the healthcare power of attorney, that explains what your thoughts are in regards to life-sustaining treatment and other things that you may be concerned about. So we're really proponents of making sure that you prepare these documents in advance so your wishes can be followed in the best way possible. You might disagree with the decisions that are being made on your behalf if you didn't give them any guidance or pick the person that's going to be making the decisions. Your family members and friends may not be able to agree. Let's go back for a second. If you look on that list, it says adult children. What happens if you have 5 of them? Who's supposed to make the decisions? Most likely it's going to be the assertive one or the one who takes control. And that may or may not be the person that you wanted to make that decision. So again, using some care in putting together a form and designating who you would like to make a decision is going to be the best way to do this. Just as a little bit of an aside, because we've got some time, many people say, well, I'm going to name so-and-so because they're a doctor or they're a medical provider or they're a nurse, and that's completely fine. But certainly to be the decision maker on these forms, you don't have to have any medical training. In fact, I would say that what's more important than medical training is going to be someone who has compassion and someone that is going to take this very seriously and make decisions for your benefit. So remember, they could always talk to doctors and families could always talk amongst themselves. So if there is a doctor or a nurse or some other medical provider in the family, that's somebody that could always be referred to, but you want to take the time to choose the person that you want to choose. If you don't do that, this can cause major emotional stress for the family member who is given the responsibility, and they may not be prepared to make them. This could also cause problems when there's more than one family member called upon to make the decisions. If there's disagreement, again, that could also cause problems. So by you doing these simple forms in advance, you're taking all of these problems off the table. You're designating the person you want and you're telling them what you want to have happen. There really is no substitute for that, even though by necessity, Illinois has a law in place that will try to put a Band-Aid on this problem if you did not fill out the forms yourself. So let's look at ways in which advanced directives and powers of attorney coordinate with your family priorities. They allow you to appoint the agents you desire to step in on your behalf for financial and medical affairs. They provide direction as to life-sustaining treatment and other personal choices that you may make. They help decide who is authorized to get your protected health information. They give your agents decision-making ability while you have the mental capacity and ability to authorize the agent powers. Again, as Karen mentioned earlier, you have to be competent enough to draft these documents. When it's too late to sign one, it's too late to sign one, and your only remedy at that point is going to be to pursue a guardianship in court.
So these documents give you peace of mind. Very important. They allow you to make immediate decisions and give you access to critical information if a crisis occurs. So if a crisis occurs, you just want to be able to focus on the situation. As Alan just said, you don't want to be worrying about having to go to court and the expense and the time of having to get a guardianship so you can make decisions on behalf of somebody who's unable to make their own. The documents are easy to put in place. They should really be among the top of everyone's list. And again, those copies of documents should be kept in a safe and an easily accessible place. We again highly recommend that electronic copies are kept in a place that you can access very easily and send off. When you need these documents, you're going to want them at your fingertips. The other thing we wanted to bring you this evening is something that we like to let all of our attendees know when they come to our presentations, because often this is something that's an available resource that is not known, and it's right at your fingertips. If you have an iPhone, you will see this icon, that white box with the red heart in the middle. If you have a different kind of smartphone, you can download a similar medical ID app. And the medical ID app allows first responders to bypass a lock screen, whether it's a numerical code or facial recognition. They can get right in and see whatever information you've listed within your medical ID app. So this becomes extremely important if you have some kind of medical condition, if you have an allergy to a medicine or to a food, if there was anything that a first responder would need to know, this is a place where you can put that information. You can put as much as you want in, as you like. But again, if you have any kind of conditions that would need to be known, it's a great resource where you can store those should something happen and somebody who's first on a scene knows to go to the medical ID apps and look for that information. This is a chart of the ideal family estate plan, and we've touched on some of these things this evening. Alan discussed that last will and testament, or the will, the living trust, which is a trust with a pour-over will. So when you have a trust, you actually have a will that goes with that. And what we talked about this evening and focused on, which are your powers of attorney and healthcare directives. So that power of attorney for property. So listing people who are able to help out with your financial affairs. The power of attorney for healthcare. If you cannot make your own medical decisions, naming those people who can step in on your behalf and make them for you. The HIPAA authorization, authorizing the people that you name to receive your protected health information. That living will declaration, again, that was that healthcare directive that if you have an irreversible, incurable injury or disease, you would want to be permitted to die naturally. So if you agree with that, you could put that in place. Assignments and deeds and beneficiary designations. Alan touched on this a little bit during that conversation about wills and trusts. Long-term care planning, very important. Possible irrevocable trust, that kind of goes hand in hand with some situations with long-term care planning, and a roadmap of your estate plan. So we did want to touch on the roadmap just a bit. So one of the things that we do when we do these estate plans is we really like to take a 360-degree look at everything that you have. So you have your estate planning documents, but we also want them to be really practical. We want you to have complete peace of mind. So at the end of the day, when somebody needs to use those powers of attorney, you know that they're in place. One thing that we highly recommend is that you create a roadmap. So it's a document. We have formal roadmaps that we use for our clients, but you don't need to have a formal document. You can create one yourself that lists important contacts. So if something happened to you, all the contacts that would need to be known of, where you keep important documents, maybe a list of your assets and your liabilities should anything happen so somebody knows. If you have a safe or a safe deposit box, how to access that, where those important documents are they in the safe? Are they in a safe deposit box? Any kind of passwords. So it's just a catch-all. And again, the way to think about your roadmap is to think about, should something happen to me, what would somebody need to know? And we have people who come into our office and they are dealing with the loss of a loved one and they don't even know what bills are paid online or what is out there. So that's what a roadmap does. It fills in those gaps. So the roadmap, just wanted to add that in this evening because we think it's important enough to just think about that, to have that information gathered. So if something does happen, that a loved one would need to know exactly whatever information you would want them to, like contacts and how to access different things that would be important for them to know. So we would love questions. You can drop them into that chat or that Q&A. We welcome questions. If you think about some of the things that we discussed this evening and you have questions after the fact, again, please reach out to us. We really do like getting questions. We want to make sure that you're well informed, that you do understand the importance of these powers of attorney and healthcare directives, and that you can put them in place for yourself and for your family so you can protect yourself not only now, but in the future. Just should anything happen, you have peace of mind that you've planned and you have those in place.
And we'll put a little plug in if anyone was intrigued by that roadmap idea. We do have a presentation tomorrow night, Stevenson Prep at 7 p.m. It's a live presentation. I still think there's some room available. So if you're interested, go online to Stevenson Prep and please join us tomorrow night if you're interested in learning more about that. We do have a question. Oh, thanks so much for the thank you, Susie. We appreciate it.
Thank you.
Look forward to talking to you soon.
Hi, yes, as always, this is such good information, and you guys make everyone think about what they should be doing if they haven't already. So that's always a good exercise for everyone.
Yeah, we're always happy. Like I said, we'll go to the next slide. But again, if you had questions and you don't want to necessarily ask them this evening, you could always reach out to us privately. Email's probably best. Our emails are right there on the screen. You could always call us as well, and we're happy to get back to you. Again, thanks everybody for we do have one question here. What are the fee differences between a will and a trust? So yes, a trust is going to be more expensive because generally it's more work up front, and doing a will-based plan is going to be a little less expensive because there's less work up front. However, we do feel that the table turns later on when the documents are needed to be used. Howard, if you reach out to us via email, we can get you some information that has pricing. There's a little bit too many variables here to just give you a round number. But if you do send us an email, we're happy to answer that question.
And I will say before Alan gets to the next question that whether you do a will-based plan or a trust-based plan, powers of attorney are included in those plans. So you'll have that power of attorney for property. You'll have all the healthcare directives. You can also, at the minimum, you want to get the powers of attorney and healthcare directives in place. Ideally, you'll have a will or a trust along with those documents to coordinate.
So we got a great question from June. She's saying if a person A gets $100 in your will, so you die and you left somebody $100, do they get a copy of the entire will and thereby get to see what everyone is getting and what money they're receiving? And the answer is yes. There's more disclosure requirements now under the Illinois Trust Code. So even under a trust, the reporting requirements are more strict. And I will point out that if you have a will, that's going to become public record anyway. So in theory, everybody on earth can see what was in the will. If you walk down to the, you go to Waukegan or you go to the Daly Center, depending on what county you live in. We're all in Lake County up here, so it will be Waukegan. I could go to Waukegan if my neighbor has passed away and there's a probate. I can pull a copy of his will. I can take a look and see, who he's leaving money to. All of that becomes public record. Can you eliminate someone from your will? Yeah, I'm going to back up to Susie's question in a second too. Can you eliminate someone from your will? Yes, of course. While you're competent to do so, you may leave your money to whomever you wish. Now, people that are supposed to get it under the intestacy statute are entitled to notice when you die. And if you disinherited to them, I guess they could make an argument that you weren't competent or somebody, exercised undue influence on you. That's always a possibility. But yes, of course, you may leave your money to whomever you wish. So you can eliminate people from your will. There's no law that says you have to give anybody anything. Are the filing fees included in your fees? So the only filing fees would be like if you're doing a trust and you're recording a deed. Yes, we include that in our flat fee. We do all of our fees for estate planning as flat fees. So just depending on what you need is the price that you pay. And all of our clients, by the way, pay the same price, unless you're insanely wealthy. If we have Bill Gates come to our office and he wants us to do his estate planning, we're going to charge him a little bit extra just because there might be some extra work involved there. But for 99.9% of our clients, everybody pays the same price, just depending on what you want to do. The only other filing fees I can think of would be for filing a will, but there's no fee for that. That's free. And that only has to be done after you die. So there are no filing fees in estate planning. If you're talking about probate, that's a whole different animal. That's an hourly project. And there's court fees and everything else. So that's why people gravitate towards trust, so they can avoid paying those large fees, filing fees and lawyer fees for doing a probate.
But there's not any place where you have to file your powers of attorney or your healthcare directives.
All right. Well, thank you, everybody.
I have a quick question for you. Do you guys have any, when you do all of your work, do you share it with them electronically?
Yes.
So you get like it all in paper, like a folder, and then like a USB drive or something like that? Very good.
Yes. So what we do, our process, we do it a little bit differently when we do our estate planning, but we start out with a worksheet, a client worksheet. You fill it out, you send it to us, and we have a complimentary meeting for everybody first. We want them to get to know us. We want to get to know them. And then after that complimentary meeting, if they want to go forward, we have them fill out a worksheet. They send it to us. The next meeting, we already have documents prepared, and we share all of those. So, they're up on a screen. We walk through them. It's very important that you understand what are in your documents. And then during the meeting, when there's questions, we'll send those questions in an email. You'll send us answers. Next meeting, we have updated docs until they're perfect. So that's how our process works. And then at that end of the process, you have a binder. All your documents are in there. So if something happens to you, you say to your loved ones, I have a binder. All you need to know is in that binder. This is how you find it. This is how you
access really good tabs too. Don't forget the tabs.
They have tabs and explanations of all the documents, and there's a roadmap in there, the whole thing, and also electronic copies. So the idea is complete peace of mind. That's what you want. And again, you have to be competent when you sign these documents. So doing them ahead of time is extremely important. After the fact, if it's too late, you're going to run into some problems.
So there's one more question. How do you decide whether to do a will or trust? There's really no short answer to that. Both of those are going to get you from point A to point B just a little bit differently. So I will say to you that we do offer a free consultation, and this is something that we go over at that consultation, the differences between the two. We did touch upon it a little bit this evening, but it's going to be a personal decision for everybody. I mean, a trust is a better way to do it, but it's going to be more expensive to set up. A will is going to be less expensive to set up, but maybe more money down the road when you pass away. Some people are like, well, I'll be dead, so if my family has to pay for probate, I don't really care about that. And that's a completely valid way to go about things, of course. So really, it's a personal decision. There's a lot of different factors. We have in the office, or if we do a Zoom meeting, we have it electronically. We call it our flip book that kind of compares everything. So we can't do that now because that'll take about 15 or 20 minutes to go through, but we're happy to, again, there's no obligation. You can schedule a consultation, and we're happy to go over that with your decision.
You could do a will if you wanted to. And like Alan said, it really depends. Some people do start out with a will-based plan and then they go to a trust-based plan later. But again, this is, it's really based on your situation. And that's why that meeting that we have for people is so important. That's why we do a complimentary, because we want to learn about your situation and give you your different options and explain to you why a will or a trust might be better for your situation, and then give you those options and work through them with you.
Yeah, we don't bite in. Again, there's no obligation. So
Right.
if you had some other preliminary questions, again, the email will be good, or give us a call. And we're happy again to offer that free 1-hour consultation. And that can be in our office in Lincolnshire, or we can do it over Zoom, whatever your pleasure. So.
All right. Thank you so much, Karen and Alan. It's always a pleasure to host you, and I always learn so much. And just know that I don't have my act together as much as I should, but I know exactly where to go when I decide I need to do everything you tell me to do every time we see you. So as I mentioned, this is recorded and I will post it online, and you guys can all share it with your friends and family that also need that swift kick that I need. So we encourage you to share that, and you can look for that in your inbox tomorrow morning-ish. So thank you again, everyone. Have a great evening.
Thanks so much for having us, and thanks everyone for
Thanks,
coming
everybody.
in. Appreciate it.